Are you considering filing a K1 fiancé visa process and want an overview of the process? Do you want to know key things before filing your fiancé visa case? The law offices of Lawrence Gruner has successfully handled fiancé visa cases for over 20 years. We know what USCIS, the National Visa Center, and the embassies are looking for in your fiancé visa case. We can help you get your fiancé visa case approved and bring your fiancé into the United States. Make sure you watch to the end, as there is a very important and not much discussed bonus tip that you should definitely be aware of in your fiancé visa case. Here are the top 10 things you should know about the fiancé visa process. Number 1. You are required to be a United States citizen. You, as the one filing the petition with USCIS, must be a US citizen. A person who is only a lawful permanent resident green card holder is not eligible to file a fiancé visa petition. Therefore, if you only have a green card and you are eligible to apply for US citizenship, you should seriously consider applying to become a citizen. Number 2. You must intend to marry each other. In order to obtain a K1 visa, you must be able to show USCIS that you and your fiancé intend to marry each other. If this is not your intent, then this is not the right type of visa for you. USCIS will require both you and your fiancé to sign affidavits under oath. These affidavits will state that you intend to marry each other within 90 days of your fiancé entering the United States. In addition, you will also be explaining how you met each other and how your relationship has developed over the time you've known each other. You will also need to prove that you have a bona fide fiancé relationship with each other. This is generally shown through email correspondence, evidence of gifts, receipts and photos of the engagement rings, evidence of trips you've taken together, affidavits from family members and friends, etc. In addition, you can help prove the bona fides of your relationship by showing Facebook posts from friends and family congratulating you on your engagement. Yes, USCIS does know how to use Facebook and other social media sites. They will check them in your case. Therefore, be very careful about what you post on Facebook and other social media sites. USCIS can use these sites to help make a determination in your case without you being aware that they are doing this. USCIS believes that these sites give it an excellent vantage point to observe your marital relationship. You must also show USCIS that you are treating your engagement like a typical engagement in your fiancé's home country. If, for example, in your fiancé's home country it is typical to have a formal engagement party, then you should have one. You need to make sure you comply with the cultural customs of your fiancé's home country. If this is not done, then your case can be denied at the fiancé visa interview level. Number 3. Meeting requirement. You must have met your fiancé face-to-face, not via Skype or over the computer, and also in person within the last 2 years. If you are childhood friends but have not seen each other in the past 2 years, you will not meet this requirement. In certain instances, a waiver to this requirement may be available. However, these are not easy to obtain. For example, you may be able to get a waiver to this face-to-face requirement based on medical or religious reasons. Not being able to afford to visit your fiancé in person is not an acceptable reason for a waiver to this requirement to be granted by USCIS. You can prove to USCIS that you have met in person by showing date-stamped photos of the two of you together, photocopies of dated plane tickets, restaurant receipts, hotel receipts, passport pages showing entry stamps to the foreign country where the two of you met, and signed affidavits by family and friends attesting, under oath, that you have met each other. Have an immigration attorney review your evidence to make sure it will be strong enough to obtain your fiancé visa. If your evidence is not strong enough, it can and should be made stronger prior to filing the case. It is much better to wait an extra 30 days, obtain more evidence, and file a much stronger case than it is to file a weaker case early. Number 4. The US citizen will have to show that he has sufficient income to support his fiancée when she arrives in the United States. The poverty guidelines are put out by the federal government and they change every year. The income requirement is not very high and it varies based on the size of your household. Your income must be at least 100% of the federal poverty line for your new household size. However, after you marry your fiancé and apply for the green card in the United States, your income will need to be at least 125% of the federal poverty line for your new household size. If your income is below the requirement, you should be able to use assets like a car, home, bank accounts, or other property to help you meet the requirement. Also, the vast majority of embassies will allow you to utilize a financial co-sponsor prior to filing. It is a rare case when our office cannot figure out a way for you to meet this requirement so you can obtain your K1 visa. Simply email us free of charge. We're very likely to be able to help you in this area. Every consulate or embassy will have their own requirements in this area, and it is very important that you comply with those requirements. Number 5. Previous fiancé visa cases can be a problem. The US citizen will only get to file 2 fiancé visas in his or her lifetime and must not have had an approved fiancé petition in the last 2 years of filing the current petition. Once again, a waiver is available, but there is no guarantee that it will be granted. If this is your situation and you cannot obtain a waiver, you may need to marry your fiancé and pursue a green card abroad rather than pursuing the fiancé visa option. Number 6. You must both be free to marry. You and your fiancé must both be free to get married, meaning that you are both eligible to get married at the time you file your petition. Do not file a fiancé visa petition with USCIS if you or your fiancé has a pending divorce. This will not save you any time. On the contrary, it will make your case take longer. My advice would be to review any previous annulments or divorces with a family law attorney to ensure that you and your fiancé are, in fact, free to marry each other. Believe it or not, some people believe that their divorce has been finalized when in fact it hasn't. Surprise! As a result, they're still married to their previous spouse and are not eligible for the fiancé visa until their divorce is final. Also, sometimes US citizens will send in documents which they believe to be divorce decrees, which are actually a different document from their divorce case, for example, a settlement agreement. Be absolutely sure that the divorce decree is the actual divorce decree in your case. Otherwise, you risk delaying the case, likely by months. It is much better to wait until you know for sure that your divorce is final than to file your K-1 visa case prematurely and have it denied. Number 7. You must not have been convicted of certain crimes. USCIS will also be looking at the criminal background of the US citizen. The US citizen must not have been convicted of a variety of crimes, such as domestic violence, sexual abuse, child abuse, dating violence, stalking, controlled substance violations, and homicide. Just to be safe, if you have had any crime in your past, then an immigration attorney should review the matter prior to you filing your fiancé visa case. It is better to take the time in the beginning to clear up any criminal issues than to have them come up during the case. You should never lie to the USCIS, and you should expect them to know about your criminal history. Also, your fiancé should be told about your criminal past. It will really hurt your K-1 visa case if, at the interview, your fiancé has no idea that you were convicted of the crime in question. It will really make your relationship seem less bona fide and can lead to your case being denied. Number 8. There is a 90-day rule concerning marriage. Within 90 days of your fiancé entering the United States, you will need to get married. You do not need to wait the entire 90 days, you just have to get married within 90 days. Your fiancé will only be able to marry you. She or he will not be able to marry someone else on the fiancé visa if someone else comes along. If she enters the United States on a fiancé visa and does not marry you within 90 days, your fiancé should plan on returning to his or her home country. You should marry your fiancé within the 90-day period so your fiancé remains in legal status. However, if you do not get married within the 90-day period, all is not lost. You still have options. Your fiancé may be able to stay. Please consult with a fiancé visa attorney immediately. Once you get married, you can then file for adjustment of status so that your fiancé may get her green card. At the same time, she can apply for work authorization. At the present time, it takes approximately 3 to 6 months for most applicants to receive the work authorization card, although this time period can be shorter or longer. Therefore, if you're sure you're going to get married, don't wait until the last minute. Get married and start the green card process so that you can obtain the work authorization and travel cards as soon as possible. Number 9. Your fiancé will also have other requirements with USCIS. Your fiancé cannot be any of the following: a person who is likely to go on welfare, a person with a communicable disease, or a person with a dangerous physical or mental disorder. In addition, he or she cannot have committed very serious criminal acts, including prostitution or drug trafficking. These are things you likely want to know before you get married. If your fiancé has any type of criminal past, you should speak to an immigration attorney to make sure it will not cause problems in your case or your fiancé visa case to be denied. Number 10. Past immigration violations. Your fiancé must not have violated US immigration laws. He or she cannot have used fraud or any other illegal means to enter the US in the past. He or she cannot have used fraud or other illegal means to enter the United States. In addition, past immigration visa violations by your foreign fiancé can put the K-1 fiancé visa process in jeopardy. These would include violating student visa rules, entering the US without a visa, overstaying a visa, working in the United States without work authorization. You can have our firm review the immigration history of your fiancé to make sure there will not be any issues in your fiancé visa case. It is much better to deal with these issues prior to filing the fiancé visa. Please note that there are specific requirements in order to bring your fiancé's minor children into the United States. If they are eligible, which in general means they are under 21 and unmarried, your fiancé's children can enter the United States with K-2 visas. please have this area looked at prior to filing. There is a follow to join procedure which would allow a delayed entry for the children, but this is outside the scope of this video. Please email us and we can make sure that there are no problems in this area. Because you watched this video all the way through, here's a bonus tip. IMBRA. You must comply with the International Marriage Broker Regulation Act. This act was enacted in 2005 and seeks to protect foreign fiancés and their children. It has many provisions, including a provision that deals with how you met your fiancé. You must comply with this act or your fiancé case will be denied. If you met your fiancé through a marriage broker or even on any sort of dating website, please consult with an immigration attorney prior to filing your case, as you will have extra requirements. You do not want a needless delay, or worse, a case denial, because your case has problems in this area. If you found this video helpful, please give us a like and subscribe to our channel. Also, feel free to email us about your immigration case. You can contact us at attorneygruner@gmail.com. Our email correspondence is free and confidential. Our main office is in Sacramento, California. We handle cases throughout the United States and the world. We have handled these cases for over 20 years, and we would be happy to answer your immigration questions. This video is for educational purposes only and should not be relied on for legal advice. Laws and requirements can and do change. Although we are sure that if we met you, we would like you, we definitely do not represent you. Always consult with an experienced immigration attorney prior to filing any paperwork with USCIS.